Just seen a couple of messages. We're just waiting another minute or so to wait for some more people to join, but hopefully you can hear me now. Let me know if there's still any audio issues, but I think it's hit 2 minutes past, so we'll kick off. So good afternoon, everybody, and welcome to this afternoon's webinar, which is on D&O insurance. My name is Heidi Buckingham, and I'm a sales and distribution consultant here at Zurich. And this afternoon, we're hosting our webinar in association with Clyde & Co. So many thanks in advance to James and Mark for giving up their time to be part of the session this afternoon. Shortly we'll be kicking off, but from Zurich this afternoon we've got Tony Statham, Sophie Halling and Mark Dowsing, and from Clyde & Co we've got James Cooper and Mark Beswetherick. Just a couple of housekeeping bits and pieces before we get going. So the webinar this afternoon is going to be recorded. I'll send round a copy of the recording following the session. Feel free to forward that on to any colleagues who might be interested in catching up. There'll also be a copy of the slides that we've gone through and a couple of other resources and a feedback survey as well. So I've seen a couple of messages saying people can't hear. I just want to check other people can hear me okay. Does the sound working for most people? Okay, yeah, I think if people can't hear, maybe catch up on the recording afterwards. But anyway, if you've got any questions throughout the session, please feel free to put these in the Q&A box and we will answer these at the end. And with that, I will hand over to Tony to kick off.
Thank you, Heidi. Hello, everybody. Thank you for taking the time this afternoon to join us on what is actually our fourth Financial Lines webinar. So we've covered crime, cyber, and employment practices. Now, I think when people think generally of financial lines, they tend to think of D&O first and foremost. It does seem like there are. Sorry, I'm just noticing some sound issues on some of the chat. But you know, as Heidi says, and I'll put in the chat, or Heidi, if you wouldn't mind, just putting in the chat for those that can't hear, which you've just done.
Yeah.
So today we are joined by one of our partner law firms who we work very closely with on the mid-market. Now, my role is head of financial lines for the UK region, so I cover really everything that we've talked about before: crime, EPL, cyber, but also directors and officers, which is really the main portion of our book. So thank you again all for joining us. Now, I'm going to hand over to Mark Dowsing, who is head of financial lines claims for us here at Zurich. And I will be around to answer any questions, hopefully. Don't make them too hard as we go through. So with that, I will take a back seat and hand over to Mark and my colleagues from claims.
Thank you, Tony. Good afternoon, everyone. And I reiterate the thanks for kindly joining us this afternoon. As Tony said, we've done a few of these before for different sublines of business, but it's our pleasure today really to present an educational piece on directors and officers claims in particular. And I have the equal pleasure, if you like, of heading up the Financial Lines claims team. Just a brief introduction to our team. We're 12 strong, including myself, and it's a mixture of what I'd term as seasoned insurance professionals and also a number of solicitors who are well versed in both formulating views on coverage on these matters, as well as, of course, involved in the defence of these cases in particular. So I guess the message is you're in safe hands, and we very much enjoy working with our broker colleagues and our customers alike in order to, frankly, get the right result and make sure the policy responds in the way it ought to, and to provide you with the best quality defence if and when you would need that. Which leads me on to a brief introduction into Clyde & Co. I've worked with Clyde & Co for many years now, as James and Mark will both attest to. Clyde & Co, as Tony said, one of our key partner panel firms who work with us closely on the corporate world and also within the SME and mid-market arena. And I'm pleased to say that if you choose Clyde & Co to provide your defence services, they're at preferential rates, and and I think we are very much in tune with working on the defence together in terms of a mutual retainer. So I won't talk too much and steal any thunder from Sophie and Clyde and Co, but I look forward to perhaps speaking with you more on the question and answers. So let me hand over to Sophie Halling, who is one of my best senior claims adjusters on the team, and she's also a solicitor, and she's going to go ahead with the main part of the presentation, and then Clyde and Co on some trends and insights.
Thanks, Mark. So I'm now going to take you through 5 points we have highlighted in understanding the D&O section of the Executive Risk Solutions Policy. Sorry, just on to the next slide. What's going on? Right. The D&O cover can be found in Section A, and it's a claims-made policy, which I will go into a little further later on. So the first point is the insuring clause, and that is the first place we'll always go to when we receive a new notification, both in terms of the insuring clause and the defined terms within that insuring clause, and whether the notification triggers cover under the policy. So it provides that the following covers are provided for claims first made against the insured company or an insured person during the period of insurance and notified to us as required by this policy. And in terms of an insured person, we will pay on behalf of any insured person the financial loss of any claim made against such insured person, other to the extent that such insured person is indemnified by the insured company. So the defined terms here, the first one I wanted to look at is who is covered, who's an insured person under the policy. It's a fairly lengthy definition you'll see here, but it includes a director or officer, but also in a limited capacity, an employee who is the company's risk manager or equivalent position, or while acting in a managerial or supervisory capacity. So very limited section there. So any notification that's against any natural person who falls within this definition of insured person and alleges a wrongful act may trigger cover under this section, and the definition of wrongful act falls within the definition of a claim. So looking at the definition of wrongful act, it includes any actual, alleged or attempted and any of the matters listed in the top of the definition as I've listed on this slide here. But the point I wanted to highlight today is under subsection A here, which is any insured person while acting in their capacity on behalf of the insured company. And this is a point that we'll see arise when we're considering notifications under this section. So it's any notification, it's always dependent on the facts, and there can be minor variables between any number of notifications, so they'll always have to be considered a fresh eye looking at all of this. But an example here could be an allegation against a director that they have or haven't taken adequate steps in respect of, say, complying with statutory regulations. So, for instance, health and safety. So arguably here, they would be acting in their capacity on behalf of the insured company. If you contrast that potentially with an allegation that a director received a preferential payment when receiving dividends, that would arguably be against them, not as director, but as a shareholder. When they received those preferential payments, it may have been as a shareholder and not in their capacity as a director on behalf of the insured company. It may be when we're looking at these points and any aspect of any notifications come in that further information is needed to understand the capacity in which the claim is being brought, and in that scenario we would always ask for that further information, which actually brings me on to looking at claims condition clause 1 in terms of notification. You might recall when we were looking at the definition, or sorry, the insuring clause, it was it includes notified to us as required by this policy. which is why I thought we'd look at this within the insuring clause. Now, it provides that an insured should notify as soon as reasonably possible, but in any event, no later than 45 days after the expiry of the policy, of any claim or any insured person being required to attend an investigation. It also provides for notification of any circumstances which may reasonably be expected to give rise to a claim being made against them, and then give written notice of those circumstances. And this plays into the claims made policy. So any claim that may arise outside the policy period but arises from a circumstance notified within the policy period may attach back, subject to it arising from the scope of those circumstances notified. The written notice that must be included, I would say the bare minimum, is a description of the claim, investigation or circumstance, the nature of the alleged or potential damage, the names of the actual or potential claimants, and the date and manner in which the insured first became aware of the claim, investigation or circumstance. As I say, I think this is a bare minimum. I would say, you know, if the insured can provide us with as much information as possible at the point of notification, it's always helpful. If they've had proceedings, correspondence from a claimant's solicitor, or from the claimant themselves, or anything else leading up to it, it's all helpful for us, not only in understanding the notification and whether it triggers cover under the policy, but also steps that may be taken beyond that, should it trigger cover, in terms of assisting the insured. So the more information, the better. And also in terms of a circumstance, I would personally say, you know, if in doubt, notify to an insured. We can always say that we need more information, or we might say we don't think it is a circumstance at that stage, but at least the insured has taken steps to comply and get that notification in at that point. So the final part in terms of the insuring clause, sorry, take you back again, is the definition of financial loss. And this includes, amongst other matters, damages, judgment, awards, or settlements in respect of any wrongful act. So that's obviously the definition of wrongful act we were looking at, that an insured becomes legally liable to pay, and defence costs. Defence costs include reasonable fees, costs, charges or expenses necessarily incurred by an insured with our prior written consent. This is another point I'll go on to a little later, but it's important to herald to an insured, you know, at the earliest stage that the policy does require our prior written consent, so that they are aware to notify really at the earliest opportunity, and we can go through what steps can be taken from there. So the second point today is the bodily injury exclusion. Now, we would only move on to looking really, I would say, at this, you know, the special exclusions, the claims conditions, etc., once we've gone through that insuring clause, and whether the notification triggers cover under the policy. Now, the bodily injury exclusion excludes cover for any claim in respect of bodily injury, sickness, disease, but also damage to or destruction of any tangible property. But underneath that, you'll see on the slide that it then goes on to say, provided always that this exclusion will not apply to defence costs. So what it's doing is there's no cover for financial loss, so damages, judgments, awards, etc., or anything else within the definition of financial loss, but it writes back in cover for defence costs. There may be a sublimit for those defence costs, and that would be in the schedule. But the purpose here really is that there would ordinarily be other insurance that would respond to these kind of claims. And if we had a notification where, for instance, this exclusion arose, we would tend to be liaising with you saying, is there any other insurance in place, and making those inquiries. The other insurance would more likely cover the financial loss and the defence costs, so the insured, there would be more indemnity available to the insured in dealing with that claim. So a potential example could be an employee injured at work, and they may bring a personal injury claim, and it may or may not include an allegation against a director potentially. But the insured should potentially have an employer's liability policy in place here, which would respond to that kind of claim. And equally, in terms of property damage, there may be, if someone's alleging damage to a car when visiting premises, say, they could have public liability or other insurance in place. And as I say, they would arguably provide the cover for the full financial loss. So we'd raise that with you and make sure that the insured is notified that other policy if that's the case. But otherwise, it would be just defence costs covered under this section of the policy. And that actually leads on to the other insurance clause, which is under General Condition Clause 12. And this sets out how this ERS policy works if there is other valid and collectible insurance in place. So, taking, for instance, the example we were looking at, if there was a personal injury claim, if there was another policy in place and they sort of cover was accepted under that policy, this ERS policy provides that it shall always apply excess over any other valid or collectible insurance or indemnification available to the insured. So what that's essentially saying, if we look at one of the earlier examples, say there was an employer's liability policy in place that had a limit of for example, 250,000 inclusive defence costs. This policy would only apply as excess over that, so it would only apply once limit under that other policy was exhausted. And if we were looking at that example under the special exclusion, that would be limited to defence costs. In terms of other insurance, there can occasionally there can also be other insurance clauses in other policies, of course, and that would all have to be considered at that time, and I think would be a whole other seminar for the purpose of this. So moving on to the next point, and that is written consent. I heralded this earlier in terms of the definition of defence costs, which requires that our prior written consent must be obtained. Under General Condition 20, this is reiterated along the line, also stating that written consent must be obtained before defence costs are incurred, any legal representative is retained to defend any insured, any offer is made or accepted, any admission or any claim is settled. In terms of defence costs, we, as Mark mentioned earlier, we have our panel firms in place to assist our insureds on this executive risk solutions policy. We've obviously got Clyde & Co here with us today, who are one of the firms on the panel. We have panel rates agreed, and given that they are there's often a scenario where they're fairly low value claims. These rates are can be preferential to an insured. Now we frequently see a scenario where an insured has maybe got a fair way through proceedings before consulting their brokers. They've received proceedings in, they've understandably wanted to protect their position, and it's only once they're a way down the line that they may think if they've got insurance in place. In that scenario, given this written consent clause, the position can be that only defence costs incurred from the date we gave consent or date of notification would be covered. As I say, all these things are considered on a case-by-case basis, but that's the general position taken. So it really is important that an insured is aware to get the written consent at the earliest opportunity. Turning again to our panel firms, they are all not only aware and used to dealing with the sort of claims that we see across this policy, but they're also aware of the terms of policy in terms of written consent, but also our reporting obligations. So we think it offers a lot of assistance to an insured when our panel firms are used. If an insured chooses to go with their own solicitors, it would be on the basis that, in terms of our consent, that their own solicitors agree to act at our panel rates, or in the event they are not prepared to do so, that the insured would pay the difference between the panel rates and the rates being charged by their solicitors. And we would generally find that most, generally speaking, when an insured instructs their own solicitors, the rates do exceed our own panel rates. So I think, you know, it can be great assistance if they are prepared to go with our panel in these occasions. So the final point is going on to fair allocation. This is claims condition 4. And this is dealing with a scenario where if one aspect of a claim is covered and another part is not, and how we would deal with indemnifying defence costs, etc., in that scenario. So it provides that if a claim made against any insured and any defendant not insured under this policy includes both financial loss, which is covered under this policy, and financial loss together with associated defence costs, which are not covered, then we and you will use all reasonable endeavours to determine a fair allocation. An example here could be if a claim is brought against a director, they'd be an insured person within the definition, and so long as they're acting in their capacity on behalf of the insured company and it falls in the insuring clause, the claim against them would be covered. Now, if it was also against a number of employees and they aren't insured persons, then they would not be covered under the policy. Assuming there's no conflicts, then it may be that it's better for one firm to be defending the director and the employees. So this is where we would need to do a fair allocation, because only the financial loss in terms of the claim against the director would fall to be covered under the policy. What we would tend to do in this scenario is, I mean, if there's solicitors acting, we may ask them how they think their time is being allocated, what proportion of their costs they think are relating to the aspect of the claim that is indemnified, and we can then take that into account in looking at fair allocation and what proportion of the financial loss, which in the first instance may just be the defence costs, would be covered by the policy. And once we've given our, formed our view, we would liaise with you as the brokers and the insured to set out what our assessment of that fair allocation would be. So that concludes this section of the webinar, and I'm now going to pass you over to James Cooper and Mark Beswetherick to take you through some D&O trends and examples.
Very much. Thanks very much, Sophie. I hope everyone can hear me. On behalf of James and I, thanks very much to Zurich for involving us in this seminar. Just on to the next slide then. Just in terms of today's topics, we want to discuss some of what we think are the most prevalent and important claims involving D&Os, particularly those focusing on the D&Os of SMEs and the challenges they currently face. We're probably going to spend most of the time today, which is about 20-25 minutes, discussing insolvency and health and safety, but we'll also pick up on some emerging areas of concern, including regulated activities and shareholder claims, as well as why we think cyber risk is likely to become more relevant for D&Os in the SME space in due course. So just moving on then to the next slide, please, if we may. It isn't easy to find significant reliable data on SME D&O claims trends, but we do have helpful recent data from the Global Directors Liability Survey, which Clyde & Co has been conducting in collaboration with Willis Towers Watson for a number of years. So the survey covers a wide range of topics and jurisdictions globally, involving several hundred respondents each year. But it's helpful in the SME context, as approximately 18% of the overall respondents were from the SME category of businesses. Just moving on to the next slide then. As you can see, if you follow down the pink column, the survey provides a breakdown as to what D&Os of businesses based in Great Britain perceive as a very significant or extremely significant risk. So you'll see there that cyber and data risks at the top, all above 40% for the SMEs in GB, regulatory breach at 40%, health and safety prosecutions, and insolvency. Those are the issues we're going to touch on today. So all very significant issues for DNOs across the UK. And then if we move on to the next slide as well, this is the data from the survey broken down by company size, in which case this case is companies less than 50 million in revenue, which is the definition of SME for the purpose of the survey. And again, we see here that cyber risk features very highly on the risk rankings among those DNOs of SME businesses, as well as regulatory breach at 47%, health and safety prosecutions at 41%, and insolvency at 51%. So the available data from those reports certainly accords with our own experience of the types of claims that our teams are dealing with across the UK, as well as what our clients are telling us they're seeing. So moving on to, if we could, to the next slide, please, and the first topic of insolvency. Just to put this in context, we just posed the question, are we in a recession? Now, it's well known, I think, to the audience that there's a clear link between recessionary conditions, company insolvencies, which leads ultimately to higher numbers of claims against directors and officers. However, technically, the UK is not currently in a recession and has fared better during 2023 than many economists predicted last year. But despite that, the UK economy is still facing a range of challenges, including rising interest rates, cost inflation and high energy prices, the cost of living crisis and its impact on consumers, but also for many businesses, a reduction in access to capital and liquidity at the moment. So the current insolvency landscape, therefore, appears to demonstrate many of the symptoms of a recessionary environment. And as you can see from the recent insolvency service data on the slide, the government's temporary support measures introduced during the pandemic, including the furlough scheme, coronavirus business interruption loans, and the business rescue moratorium to prevent creditors taking enforcement action, did keep insolvencies at bay during the pandemic, with corporate insolvencies reaching their low during the pandemic of fewer than 750 per month in February 2021 there on the slide. But since then, as you'll see, there's been a rapid rise. In August 2023, 2,308 firms in England and Wales collapsed, which is 19% more than in August 2022 and higher than pre-pandemic levels. The breakdown of figures also shows, if you look at the two lines there, that the increase is largely due to a rise in creditors' voluntary liquidations, in which companies voluntarily wound up either by its directors or its shareholders. And there were 1,880 creditors' voluntary liquidations last month alone, which is 13% higher than August 2022. And also noteworthy from the insolvency service data is that the construction, retail, and manufacturing sectors head the list of the sectors that are worst affected. And the insolvency service noted that one of the biggest drivers was action by HMRC, which has significantly increased the number of winding up orders for unpaid tax in recent months. So while the UK had initially avoided the avalanche of companies going bust predicted in the months after the COVID pandemic first hit in early 2022, it's now seeing the effects of tighter and more costly lending on the finances of firms, which are already less vulnerable by the cost of living crisis. And so the expected insolvencies are coming through in much higher numbers. And many commentators are predicting that this upward trend in corporate insolvencies will continue for many more months to come. So we are in an unusual economic position, and the lessons from previous recessions in the early 90s and 2008 onwards can therefore only take us so far in predicting the outcomes this time. But that said, the exposures arising from this set of economic circumstances and challenges is likely to be familiar. So if we could just move on to the next slide, then, just to think about the insolvency as a driver of claims. As we saw on the last slide, insolvencies have now reached their highest level since the global financial crisis in 2008-9. The increased focus on directors' conduct has come in part from the insolvency service itself being given new powers to investigate directors of dissolved companies. These new powers were a direct response to the much reported bounce back loan fraud and abuse of the furlough scheme during the pandemic. This has led to more actions against DNOs for breaches of insolvency legislation and their duties to the company, in addition to disqualification proceedings. The number of disqualification proceedings brought by the insolvency service is now getting back to pre-COVID levels in this year. Over half the disqualification orders imposed in 2022-23 related to the abuse of the COVID bounce back loan scheme, in addition to its civil and criminal powers. And this month, for the first time, the insolvency service has also noticed that it's used for the first time its powers introduced on the 1st of October 2015 to seek compensation orders. So the first example was recovering £50,000 from a former director of an SME, Deer Construct Limited in Croydon, in addition to disqualifying that particular director for 13 years. And finally, worth note, the average ban in the last year is now 7 years and 3 months, which is significantly up from the average over the period prior to that, the prior decade up to 2022, in which the average was varied between 5.5 and 6 years. So there's more actions, and the bans imposed on directors are longer. Importantly then, in terms of the inquiries by insolvency practitioners, as many of you will know, insolvency practitioners are obliged by law to examine the decision-making of directors in the time leading up to the insolvency, and claims arising from this period can be expected. With more insolvencies, there are more inquiries by insolvency practitioners into the activities of directors at the relevant times, in addition to claims by trustees against DNOs, and therefore civil, regulatory and disqualification proceedings will follow as a result. Further, during these difficult economic times, there's a much higher risk of fraudulent, dishonest and wrongful actions. The rise in insolvency means directors should be particularly conscious of wrongful trading and other offences under the Insolvency Act 1986, including misfeasance allegations and insolvency practitioners reviewing preferential payments and transactions and undervalue. And of particular note, when a company becomes insolvent, the director's duties that are codified in the Companies Act, which we all know well, such as promoting the success of the company and having regard to the likely long-term consequences of decisions made, are displaced, and the directors are then obliged to consider the interest of creditors as paramount and to take those interests into account during when carrying out their duties. So directors should therefore be aware of the possible dangers of entering into what's often called the twilight zone. This zone starts as the company is approaching insolvency and usually happens at the point between when a company begins to face financial difficulties and the commencement of insolvency proceedings. And unfortunately, that tipping point isn't always easy to identify between those two phases and can be quite difficult to pinpoint. But from a legal perspective, the Supreme Court in the BTI 2014 and Sequana case in 2022 indicated that this is when a company's liquidation is either probable or bordering on insolvency. So it certainly applies before the company is actually insolvent. And if a director breaches its duties to the company and or the creditors during the twilight zone, they could well face a number of actions under the UK's insolvency regime, as well as under the Companies Act. As soon as the director becomes aware that the company is approaching already in the twilight zone, it's therefore critical that both legal and financial advice are sought. And if an administrator or liquidator is ultimately appointed, it's likely that it will want to build a picture of the director's decision-making before the insolvency event. It's therefore crucial that a paper trail is kept. Regular board meetings should be held with accurate minutes being taken and additional meetings being held whenever significant changes and events occur. Directors should also prepare a focused business plan, setting out how they propose to get back to a solvent position, and meet regularly to review the ongoing financial position of the company and its progress as against the business plan. Relevant transactions, by which I mean those over a certain amount or outside the company's usual scope of business, should also be carefully reviewed, and directors should ensure there's valid reasoning behind the entry into those transactions and that they're properly documented, recording the commercial rationale. The directors would also be well advised to liaise with suppliers in this time to consider credit terms which may help alleviate current and short-term cash flows. They would also be make sure they're able to justify their continuing belief at any given moment in the merits of continuing to trade. And finally, one thing that directors should not fall foul of, particularly if facing difficulties in insolvency, is making hasty decisions regarding transactions that are viewed as having been made at undervalue. So these types of transactions will typically involve companies that either make gifts or the company receives no consideration at all, or indeed where the consideration received is significantly less than the value of the asset. And those particular concerns of insolvency practitioners when they're looking at insolvent directors' behaviour. So just to conclude then, the insolvencies are continuing to rise, and inevitably, given the number of causes of action we've discussed, that is also causing a rise in the number of D&O claims arising from insolvency in the current economic climate. And on that note, I'll pass it to James, who's going to talk about the health and safety side of the claims experience we're seeing at the moment.
Lovely, thanks, Mark. So first of all, just a shout out to our specialist health and safety defence team in Manchester. They've helped prepare this part of the session. Mark and I tend to do the insolvency, civil, regulatory type areas. We have a specialist team who do the health and safety work. So as you all no doubt know, all companies have got a duty to ensure the health, safety and welfare of their employees while they're at work. And that derives from common law, also the Health and Safety Act, but also a myriad of regulations which have been passed under that Act. And because the directors direct and control the company, they are responsible for the implementation and maintenance of adequate procedures under the Health and Safety at Work Act. Now, that includes a written health and safety policy where the company has got more than 5 employees. They have to provide safe equipment, plant and systems of work, safe use of hazardous substances and articles. They've got to undertake periodic risk assessments and generally take steps to ensure that the workplace is safe for employees. They've also got to make sure that the workplace is safe for any contractors or any third parties and even public visitors. So in practice, there is a vast range of regulations. That list is way too long to mention here. So the obligations that directors need to know about requires a really significant investment of their time to really try and grasp the key issues for which they've got responsibility. Now, on top of that, directors are often required to assess whether the measures in place comply with the common test under the Act of what is reasonably practicable, which introduces subjectivity and therefore a degree of confusion and uncertainty into their decision making, which is really never helpful. Directors have also got to set the tone from the top on health and safety issues. So they've got to ensure that operational management teams develop and maintain a positive health and safety culture throughout the company. But even with that extensive guidance that's available for directors on the Health and Safety Executives website and elsewhere, it is common for companies and directors to fall foul of the regulations, really because of the scale and complexity. And unfortunately, that's particularly so for SMEs because they often just don't have the resources to fund a specialist team, and they tend to rely on generalists for their operational support. So health and safety prosecution numbers have fallen in recent years, but unfortunately, they do have an incredibly high conviction rate when they bring those prosecutions. That rate at the moment sits at 94%, and that's significantly higher than the average for general criminal prosecutions, which is at around 84%. So as Mark indicated earlier, it's not a surprise that in the survey we did that 40% or over 40% of Ds and Os of SMEs surveyed saw this as a very significant or an extremely significant risk for them. Now, what you'll see on the slide at the moment are the 2 main offences that directors and officers should be concerned about. The first one is Section 37(1) of the Health and Safety at Work Act. That offence is serious. It carries a maximum penalty of 2 years imprisonment. The second is gross negligence, manslaughter. That's committed where a death is the result of a grossly negligent, albeit otherwise lawful act or omission on the part of a defendant. And that offence is even more serious because it carries a maximum penalty of life imprisonment and unlimited fines. Both of the offences will typically also see the company prosecuted. Defence of that is quite often funded via an ELPL type policy. Now, when directors are convicted under either offence, the Disqualification Act also permits the court to impose at its discretion a disqualification order without the need for any additional investigation or evidence. So you can see that this is pretty life-changing if a director gets prosecuted for one of these 2 offences. And we can move to the next slide, please, Sophie. Now, it's pretty clear that the risk of a prosecution is much higher for directors of SMEs than it is for large companies, and there's a number of reasons for that. Within SME, the proximity of a director to the incident itself or the decision-making which led to the acts and omissions which directly contributed to the death or serious injury, that's a real relevant factor that increases the risk of prosecution. Also, SME directors tend frequently to still be working on the tools or are very much hands-on within owner-managed and family businesses. That's obviously contrasted with large and very large organisations where there's really quite often several layers of management between the CEO and the construction site or recycling site, etc. So it's much more difficult to prove the knowledge or involvement required to support a prosecution. The consequence of this is that prosecutions of directors of large companies are very rare and they seldom are successful. But SMEs, however, can rarely afford to employ sufficient or any health and safety professionals. That increases the risk of non-compliance and also means that directors retain the responsibility for formulating and maintaining adequate policies and procedures. There's also quite often less of a challenge or accountability within SMEs around health and safety. So as such, problems that are identified are often less likely to be called out and remedied. If we can move on to the next one again, please, Sophie. So here, just to give you a slightly more cheerful tone, there's a couple of recent live examples from the cases that both our team has dealt with, but also have been seen in the press. They're all pretty grim reading. If you Google some of them, they really don't make very nice reading. So when you look at Decopack, for instance, there an employee was crushed to death by a robotic packing arm. The director was sentenced to imprisonment for 5 years. And one of the pretty horrific things about that case was that when the piece of machinery was installed in 2015, within a week or two, all of the safety mechanisms in that piece of machinery, which later caused the death, had been taken off or switched off by the director. So it was a pretty egregious claim, and there you can see what happens when that sort of thing does occur. Greenfeeds was the death of a couple of employees by drowning in a tank which contained pig feed. That must have been a pretty horrific way to die with semi-liquid materials going into people's lungs. So there you see 13 years of imprisonment for gross negligent manslaughter and also health and safety offences. And on top of that, another co-director sentenced to 20 months imprisonment for health and safety regulation breaches. These fatality cases also tend to last an incredibly long period of time and are very expensive. So a fatality case typically lasts between 4 to 6 years from the date of incidence. They're also likely to include a criminal investigation, a separate coroner's inquest, and then the criminal trial. And costs of those can be very, very high, often in the range of £600,000 to £1.2 million per individual. And obviously, in those cases, each D&O is generally represented by separate legal teams, so it can be very expensive. So you can see that these health and safety prosecutions, which I think people quite often forget about, or thankfully within the survey it looks like SME directors at least are really thinking about them. But you can see here that the risk for SMEs is pretty high, but that associated cost is really pretty significant for directors and officers of SMEs. If we can move on, please, Sophie. So this one, I think, rather than really go into any real detail here, we just wanted to give a little flavour around some of the other regulated activities which Ds and Os can get brought into. So obviously a financial services type SME, which is regulated by the FCA and PRA, we know that that regulator, particularly post the global financial crisis, is now significantly more hands-on, significantly more intrusive and significantly more aggressive. Those enforcement trends around financial crime, unauthorised business, pensions, etc., are still continuing to really be a big part of what the FCA does. And over the past decade, they have tried to focus on individuals, because what they do know is that in order to change the culture of an organisation, they really need to find an individual to pin something on, rather than just bring or levy a fine against a institution for whatever sum of money they can afford. Much less likely to change the culture than if they fine an individual. So anyone regulated by the FCA and PRA, it's a significant issue for directors and officers, and shows the real importance of having this type of product available to them. And what we're seeing is around all of this sort of thing, it's sort of an increase around what are we doing around regulation of individuals. So we have the senior manager certification regime, obviously in the financial services. It's likely to change, we think, over the next few years, but there will always be some kind of regime around individuals, and we are expecting to see more cases brought against individuals under the SNCR enforcement regime over the course of the next couple of years. There's also some changes brought in the Economic Crime and Corporate Transparency Bill, there is an attempt, I think, to change this concept of what the directing mind and will of a company is, in order to bring an individual's knowledge within the ambit of the company. And there it's going to be a change in the directing mind and will, which in an SME is often this, something like this, the majority shareholder, the MD, that sort of thing, changing it to now senior managers. So a much lower burden for the regulators to bring a claim against the company. Now, that doesn't automatically increase the likelihood of a claim against an individual, but what it does mean is that if those individuals get brought along for some kind of interview, the cost of their legal advice can be expensive, and that's again why one of these policies is so important. We've got something in there around shareholder claims. I think really just to drop it in, it's not really an SME issue, because certainly Section 90 and 90A is all around companies which are now publicly listed. And obviously not many SMEs are publicly listed, but some are. And so we're currently within the team defending a Section 90 case, which is all to do with a initial public offering. That initial public offering raised £50 million. Now, a lot of money, but actually for an SME, that's the type of things that we're seeing SMEs starting to do. So I think also having in mind the importance of a D&O product around if your SME is either publicly listed or about to become publicly listed, whether or not a product or an enhanced product around this type of issue is important to cover defence costs. So with that, I'll pass back to Mark just to wrap things up.
Great. Thanks, Sophie. Just in terms of things to watch then, picking up on what James said around, we talked about some existing claims areas, but things that we're either seeing started to come through or expect will come through in the next couple of years. And so, as you'll have noticed from the early survey slides, cyber risks, which separately includes a number of different categories. So that includes data loss, cyber extortion, social engineering fraud, and other cyber crimes, quite a few different categories there. That rates among the highest risks that DNOs of SMEs are worried about. And I don't think, certainly from our experience, that's based on the current claims experience, but it's certainly forefront in their minds at the moment. So this slide just tracks the evolution of cyber as a growing risk for DNOs globally. And as you can see, in 2004, it was not on the radar at all. It didn't even make the top 5 in any form. And yet in 2023, 9 years later, it holds all the 3 top slots, which demonstrates just how rapidly this has risen in importance for DNOs. And in the SME space, as I said, we're not seeing that many claims against DNOs arising directly from cyber risk yet, but it is likely to follow because it's already a major source of litigation and investigations against DNOs of listed and other very large entities. And because a major cyber incident is effectively an existential threat to any business, it's relatively easy to see how any failure to take reasonable steps to prevent those attacks, or indeed things like failing to insure adequately against the consequences of a cyber attack, can easily be used to frame against the director for breach of their various duties. But just to give you an example, one claim we have seen and how simple it can be to frame a DNO claim based on cyber risk. We're currently dealing with a claim by a smallish entity whose CEO and director signed off on a $5 million transfer of funds that unfortunately was actually a social engineering fraud and was irretrievably sent to the wrong counterparty as part of a concerted fraud. So his employer then dismissed him, brought a civil action against him for breach of his director's duty to act with reasonable skill and care in approving that transfer, and then notified its own claim under the DNO policy for an indemnity in respect of the CEO's anticipated liability to the company. And so in the context of vast cyber fraud and threats on businesses, it's easy to see how those types of claims could be modelled on those broad breaches of directors' duties. Just moving on then to the last slide, if we can. Just in terms of other areas to watch, bribery and corruption featured in the survey as well. I mean, I think at the moment, from our perspective, it's much more likely to be an organisational problem for SMEs than for the directors themselves. And that's particularly so given the limited enforcement resources with the criminal prosecution authorities in the UK and elsewhere available to investigate and prosecute corporate bribery offences and the individuals involved. So really down to a lack of resourcing just to pursue the individual claims at the moment, unless they're particularly high value or high profile. Similarly, with the failure to prevent fraud offence, which is in the press a lot at the moment, the proposed offence of failing to prevent fraud appears to be more relevant to the liability of organisations than DNOs themselves at the moment. But it's certainly worth watching because DNOs can be liable if they fail to ensure that their organisations have adequate anti-fraud policies, systems and controls, etc., to manage those risks. So as that becomes a more important issue, it will be rising up the agenda for DNOs to focus on as well. And then finally, we just mentioned ARGA there as well as the thin end of the wedge. And this, again, we think this is one for the directors of SMEs to keep an eye on in terms of the proposed audit reforms. So these reforms have the potential to markedly change the liability landscape for directors and officers of public interest entities. So that at present, the Financial Reporting Council is to be replaced by a new regulator known as the Audit, Reporting and Governance Authority, or ARGA, which the government proposes will be given the necessary investigation and enforcement powers to hold all directors of PIEs to account for wrongdoing in cases where there have been breaches of directors' duties relating to corporate reporting and on audit, etc. So whilst this regulation doesn't yet apply to SMEs, it could mark the thin end of the wedge as regards the introduction of codes of conduct and/or general regulation that's applying to directors of all companies. So just on a similar note, in terms of that similar trend, in 2022, the Institute of Directors, the majority of whose membership are actually SMEs, published a consultation paper proposing a draft voluntary code of conduct for all UK directors, who would therefore be encouraged to become signatories to the code and voluntarily commit themselves to principles in order to be held more accountable to wider society. So we think that might be a sign of a broader intent to regulate the conduct of directors across sectors and across size of business. So it's just another one to watch. But that's hopefully a useful overview of the types of things we're seeing are prevalent in terms of claims trends, but also some of the things we're keeping an eye on the horizons that might be of interest to SMEs. So I think that's all from us, and we'll pass back to Sophie and to Mark.
Thank you.
Again.
Mark, sorry, Heidi, just very quickly, I forgot to mention something at the front end, and it's just really to flag up our SME mid-market claims brochure, which is very useful, ready reckoner really for our claims colleagues in the broking houses to be mindful of, and it provides an overview of the executive risk solutions policy and also some hints and tips on what should be included in terms of a notification email or message.
Thank you, Mark, and thank you to all our speakers for this afternoon. That's a brilliant session. We've got a few minutes just to get through some questions. There's a few in the Q&A box already, but if you've got any more questions, please feel free to pop them in there. So first one, would similar cover be provided under professional indemnity? And then Peter's also asked about claims examples, which we have covered some of later in the session.
I'll take this one. The short answer really is no. The two are fairly mutually exclusive, D&O and PI. So you'll find in almost all, and certainly all I've ever seen, PI policies, a directors and officers exclusion, and in 95% of D&O policies, you'll see a PI exclusion. Now there are sometimes some costs and things like that, but no, the two don't dovetail at all, really. So there are certain claims that could be potentially picked up under both, for example. So if there was some negligence that resulted in injury or something like that, then PI can often respond to that. But you really shouldn't rely on a PI policy to pick up D&O claims and vice versa. They are mutually exclusive. Yeah.
Thank you, Tony. I can see a couple of hands up. Do you want to pop the questions in the Q&A box and we'll work our way through them? The next one is, would the exclusion of property damage also relate to financial loss following property damage cover, i.e. if a director fails to insure properly and the property insurer can't respond fully?
That was quite a question, quite a mouthful question. That, in all honesty, I think everything would be considered on a case by case basis. The actual exclusion, I'm just going to bring it up in front of me, is any damage to tangible property. So we'd have to consider beyond that. What was the second part of that, Heidi? Because it was a rather.
Would the exclusion of property damage also relate to financial loss following property damage cover, i.e. if a director fails to insure properly and the property insurer can't respond fully?
In all honesty, I think we just have to look at the facts as they were presented with the notification. It's quite hard to give an exact answer here as to whether it would or it wouldn't cover it. Everything is so fact dependent when we're looking at notifications, which is why, as I said, we always start from the beginning and you always look at the insuring clause and what's there. So I apologise, that's not a particularly full answer, but it's a hard one to consider.
That's all right. Thank you, Sophie. Next one, in what circumstances, if any, do you have the ability to subrogate your losses?
So yeah, I mean, as insurers, we always retain or reserve the right, if you like, to a subrogated claim down the track. That is very much done on a bespoke case-by-case basis. We obviously consider the commercial relationship that our own customer will have with the potential defendant on the subrogated action, but if that's a goer, then we look at the merits of such a claim, and you know, frankly, the prospects of recovery need to be pretty high in order for us to go down that road. But certainly that is something that we'd look at, and we tend to reserve rights on in terms of stepping into our customers' shoes but working with them in order to recover some money back into their policy limit, frankly. So, yeah.
Thank you, Mark. Next one, would the recent high-profile insolvency of Wilko be a good example of the points you've raised under the insolvency section of your presentation? Richard, I can see you've also mentioned about sending out the claims guide. I'll include that as an attachment to the follow-up email.
Yeah, I think it definitely
Oh,
would. Sorry, I was going to say, I think it would, just because it's been in the press in the last couple of days. Actually, I think there's already suggestions that the director's conduct is under scrutiny, and that some of the questions around dividend payments is always a big issue, particularly with family-owned businesses. You know, anyone taking dividend payments out through that type of entity will come under scrutiny as to whether or not that's the right thing to have done, when that company was clearly facing financial challenges for a long period of time. So any of those dividends paid during that period when it started to come under financial pressure will be subject to scrutiny. So I think Wilko is going to be a very good test case of exactly what a high-profile test case of what we were discussing earlier on. Yeah.
Yeah, and I would just add to that. Look, that's exactly what the Twilight Zone. You know, that was what I was going to say. You know, it was mentioned earlier when these businesses are operating in that Twilight Zone between, you know, look, are we going to survive? And yes, just to Mark's point, look, I think there is some scrutiny to be had against what the directors of Wilko's were doing while they were in that sort of limbo state, frankly.
Thank you. Next one, what do you see for the future of the D&O market?
I'll take this one. So, look, from our perspective, we've been writing D&O in the SME space for years, decades, and we are committed to grow. So we are actually re-releasing our mid-market suite of wording. So our ERS policy will be re-released towards the end of this year to the start of next, which will be including some tangible and fairly market-leading upgrades. So there is more on that to come. Now, you know, that sort of demonstrates our commitment to grow, to support our brokers, to help our policyholders navigate through some fairly choppy economic waters. I think the most interesting point really is I'm sure most of you on this call have noticed or recall the hard market that we had sort of during COVID, which is a fairly ambiguous phrase because everybody seems to have it again now, don't they? But during COVID, and now the rate seems to have dropped off a cliff again. As we've seen, the support from furlough, the loans, the you know, general propping up, that all has to be paid back at some point. D&O claims tails can be fairly long, so 3 to 5 years is not unusual. What I think we'll see is if we haven't seen it already, actually, is a leveling off of some of the rates now. So I think we have probably dropped as far as we're going to go. You can't always say that on a sort of individual case by case basis, but I think overall, look, if we're seeing it, so is everybody else. I don't think we will see many new entrants really, because it's proven quite volatile over the past sort of 6, 7, 8 years. But it's a competitive landscape, you know. It's quite hard to underwrite well. but you know, look, it's everybody wants sort of SME business, don't they? So I think it will remain a competitive marketplace, but I think we have seen a leveling off now. You know, I could be very, very wrong in that, but look, we are looking at our own rates, we're looking at our own wording. We think there's more we can offer the market. So look, please keep your eyes peeled for news from us on the D&O side of things in terms of our products and our rates.
Thank you, Tony. Conscious of time, we're now running over. If anyone has any other questions that they'd like to get in touch with,
Well, Teresa Dixon's had a hand up for a while as well, yeah.
Did you want to pop your question in the chat, or I can allow your mic?
No.
Should be able to come off mute if you did want to ask a question, Teresa. If not,
No.
Looks like we've got one more. Health and safety investigation costs. You discussed fatalities and convictions. Would defence costs be covered if someone is injured and no conviction imposed by the HSE if such costs are not covered under the ELPL policy?
So if the claim is brought against a director, then the policy should respond to the costs as they are incurred. And it will not be necessary for there to be a conviction in order for the policy to respond. It will respond as and when the costs are incurred. So it does not require a finding of guilt. No.
And I guess, thank you, James, just to complete that analysis, if you like, if there was a conviction and a guilt as a final judgment, if you like, then under the policy there is a right of recourse in relation to defence costs and that sort of thing, just in terms of the conduct exclusion potentially being at play. But yeah. So Heidi, just very quickly as well, I just wanted to add, if anyone genuinely has any further questions to Zurich and or to Clyde & Co, please do circulate our email addresses and as such from the claims perspective as well, just to, we can certainly cover that off, and any questions on defence work and the like, I'm sure James and Mark would be only too pleased to discuss that directly with brokers and customers.
Happy to.
Brilliant. Thank you, Mark, and thank you so much to all of our speakers this afternoon, and thank you to everybody for joining as well, and for all your questions. I hope you enjoyed the session. As I said at the start, I'll send around a copy of the recording and the slides and the claims guide that was mentioned as well, and I can include everybody's contact details, so if you do have any more questions, please feel free to get in touch, and hopefully you'll be able to join another one of our webinars soon. Thank you, everyone. Have a good afternoon.
Thank you.
Thank you.
Thank you.
Cheers. Thank you.
Thank you.
Thank you.